as always, it's great to be back with all of you who have chosen to spend some time with us on a Tuesday. We have, for this very last day of September, plenty to cover. You will not see too many slides. Our speakers, by and large, are going to be sharing their thoughts orally. But don't worry, this will all be recorded, and you can go back and take a peek at what we have to say. If you missed anything, and as is always the case, we will have the email addresses of the speakers at the ready, so that if you want to write a note afterward, you can also just reach out directly. But let's go through the agenda, Kathy, so that everyone has a sense of what we're going to be covering. Thank you for advancing. I appreciate it. So today is September 30th. As I mentioned, it is also the last day, theoretically, that our federal government will be functioning, because we don't have a approved blueprint for the next fiscal year, which starts tomorrow. Negotiations are feverishly underway, and we may know more later tonight. We also may have a federal government shutdown tomorrow, which certainly we've experienced before, and that can affect things from training for air traffic controllers to how folks delivering telehealth via Medicare will get reimbursed. There are lots of implications, and we will be making sure that we keep tabs on all of that for all of you. So for the moment, though, the government remains operational, at least for a few more hours at the federal level. I'll also note that here in New York City, where I'm speaking with you from in Midtown, over the last few days, there's been a bit of a shakeup in the mayor's race. Mayor Adams will not be seeking re-election to another term, which gives a little bit of an opening theoretically, though we shall see, to former Governor Andrew Cuomo, who is, of course, running again, despite the loss to Zohan Randami during the primary, and Mamdani still has a strong position of leadership in the polls. The polls didn't predict his win in the primary, so who knows exactly what will come there, but certainly we here in New York City are watching that, and I know across the state, many of you are in whether cities or other municipalities with elections upcoming in early November, so we'll be keeping tabs on all of that for you too. For the moment, though, let's move to the topics for the day. We will and thank you, Kathy. I think we've covered that slide, but I'm just going to walk through the agenda a little bit further. First, we have Nicole Macris, who will be on the program. Nicole and I co-wrote a piece about essentially some of the shifts that are beginning to occur following the passage of the One Big Beautiful Bill Act, HR 1, the reconciliation bill, called lots of different things. And there are implications in New York State that are going to start to be felt in the Medicaid program. Nicole's going to highlight those. Ksenia Premo is back on from Syracuse, and she's presented many times over on immigration matters, and there are new proposed standards concerning the H-1B process. Frank Mayer is going to shift back to HR 1. He's spoken about that before, of course, and what Frank's going to be covering out of the Albany office will be HR 1 language that affects various modalities of educational assistance, an interesting area that we haven't delved into so deeply as yet. And so, Frank, thank you in advance. Kamisha Parkins, also with me in the New York City office, will be rounding out today's presentation with an interesting proposal and path, essentially, that the district attorney in New York City, specifically Manhattan, is pursuing concerning wage fixing. So with that, let's turn first to Nicole Macris, who's an associate who splits her time between Syracuse and Rochester, and also sits in our government and regulatory affairs practice. And Nicole, please update this group on this shifting set of really priorities in terms of how funding is being dispersed, and what it may mean for New York State now and going forward, as well as the constituents that many of the organizations that might be tuning in are serving. So Nicole, really the floor is yours, and thank you.
Thanks, Gabe. Good afternoon, everyone. Nicole Macris here. Gabe Overfield and I recently looked into the effect that HR 1, more commonly known as the Big Beautiful Bill, will have on New York State's continued attempt at expanding healthcare coverage to all New Yorkers. In some, less people will be covered, and New York State is pivoting in an attempt to blunt the effect on individuals. For a little background, in March of 2024, the U.S. Department of Health and Human Services and Department of Treasury approved New York State's 1332 waiver, effective through 2028. The waiver allowed New York State to pursue innovative strategies for providing residents with access to high quality, affordable health insurance. HR 1 cut funding for New York State's 1332 waiver. New York State will lose $7.5 billion in annual funding as a result, which was directed to expand its essential plan. Now, the essential plan was available to New York State residents that were lawfully present in the United States between the ages of 19 and 64, not eligible for traditional Medicaid or Child Health Plus care, not eligible for employer or other coverages, and they would be able to demonstrate sufficiently modest income. The essential plan was expanded last year, becoming available to New Yorkers who were not eligible for Medicaid, and who had incomes up to 250% of the poverty level, so approximately $39,125 of an annual income for a single person. Upon analysis of the cut, due to HR 1, New York State's Department of Health determined that the best course of action was to terminate its 1332 waiver and reverse the essential plan expansion, while simultaneously reactivating its basic health program by July 1st of 2026. Note that this is subject to public comment and to the approval by the Centers for Medicare and Medicaid Services. The purpose of this is to attempt to retain insurance for the greatest number of persons. Approximately 450,000 of the 1.7 million affected by this cut is expected to lose coverage due to the switch. This is an evolving issue, obviously, and we are keeping a very close eye on the effects, the ways that New York State is pivoting, and we will continue to provide updates as this unfolds, as well as information regarding the steps that New York State is taking to blunt the effect of the fallout from HR 1 and this consequential cut.
Nicole, thank you so much for that update. And for anyone wishing to read our piece, it's available. You can just let Nicole or me know and we'll get it to you. But this is potentially the beginning. We know that in New York State, there's going to be a budget process upcoming for the fiscal 2027. And as a consequence, there's going to be more maneuvering, as it were, around lesser funds to work with for the coming fiscal. And it's going to be certainly something that we will be bringing, to all of you in the form of update as we move into the fall. So again, Nicole, thank you so much for this time. Let's move to Ksenia, who's with us from Syracuse and who has information to share on the H-1B lottery and a proposal via DHS. There's already been a significant amount of movement in the immigration legal space, and we've had a number of presentations in the last couple of webinars alone. But Ksenia, what is new yet again? We certainly want to learn more.
Thank you for the introduction, Gabe. Good afternoon, everybody, and thank you for joining us. As you know, DHS, Department of Homeland Security, recently proposed a rule which would change the H-1B lottery drastically. Many of you are familiar with the current H-1B registration process, and for private clients, the H-1B lottery is one of the most frequently used ways to bring international talent to the United States. Under the current H-1B lottery, we start the process sometime in January, collecting information from employers regarding the candidates they would like to enter into the H-1B lottery. And the lottery typically opens up in mid-March, then we submit our registrations, and then we wait for results in April. And the registration process at this point in time is relatively straightforward. It requires submitting very limited information. It is not difficult to register folks for the H-1B lottery. And the H-1B lottery, as you know, is completely random at this point in time. So all registrations go into one big pool, and the employers and the candidates are selected by USCIS from that pool on a completely random basis. So the new rule that was just published would drastically change that process. What the government is proposing is to use a wage level system to prioritize H-1B registrations. Each H-1B worker, when we file the H-1B petition, we need to submit the labor condition application and indicate whether they're going to be paid at level 1, 2, 3, or 4 wage. And level 1 is the lowest wage and level 4 is the highest wage. So what the government is proposing to do is to use the leveling system to determine how many times each employee is allowed to participate in the H-1B lottery. So for example, if you're hiring somebody with a level 1 wage, that person will be entered into the lottery 1 time. If person is going to be paid level 2 wage, they will be entered twice. If they're being paid level 3 wage, they're going to be entered 3 times. And of course, if level 4 wage, then they're going to be entered into the H-1B lottery 4 times. So that's a very, very significant change, and it is going to impact how the employers recruit and set wages and enter folks into the H-1B lottery. Obviously, the system is going to prioritize and give greater preference to folks who earn higher wages. And the government seems to equate higher wage with more skills and lack of that talent in the United States. So the new system is going to be very disadvantageous for entry-level positions. And for foreign students that are graduating from U.S. colleges and universities, and then seek to work in the United States, first pursuant to F1 OPT status and then STEM EAD, and are hoping to transition to the H-1B. So it's going to be harder for them to get those H-1B numbers, because typically when they're recent graduates and they're starting to work for private companies, they're paid at a lower wage. We anticipate that there are probably going to be, some lawsuits filed challenging this particular wage system preference. We anticipate that the arguments are going to be that, discriminates against younger workers. Another potential argument is that DHS exceeded its rulemaking authority in implementing a rule like that, but that remains to be seen. The earliest this is going to be implemented is going to be for the fiscal year 2027. The H-1B lottery for that will take place in March of 2026. So it is possible that we will see the implementation of that rule by then, unless it is delayed by litigation. The one thing to keep in mind that if this new system is implemented, then the H-1B registration process will become a little bit more cumbersome, because a lot more information will be required upfront for the filing of the H-1B registrations. At this point in time, when we are doing the H-1B registrations, we are not identifying position or wage level on our H-1B registration forms. We will be required to provide that information in connection with the new H-1B registration process. We will need to be very careful about our job titles. We have to be specific about the location of employment and what wage we're going to be paying to this prospective H-1B employee. Because when we file the H-1B petition, that information will need to match with our H-1B registration. And if there are any major discrepancies, it is possible that the USCIS may revoke the petition. So in terms of next steps, if you rely heavily on the H-1B talent, this may be a good opportunity for you to review your existing LCAs and see at what levels do you typically sponsor H-1B employees. If you find out that, the vast majority of your H-1B lottery entries are at level 1, you may want to consider other strategies and be ready to address those issues. And another thing that I will mention in closing is with respect to possible federal government shutdown. It will impact the immigration world in terms of the Department of Labor. The LCAs are not going to be processed for the duration of the shutdown, and the perm applications are not going to be processed for the duration of shutdown. That's it, Gabriel. Thank you.
Thank you very much, Ksenia, and thank you for making that connection to the shutdown. It has myriad implications that we will be watching play out in real time if indeed it does transpire. And of course, we're here to help in whatever respect we can. Let's turn to our next speaker, please. And that's Frank Mayer, who's with us from Albany. And Frank has spoken before on HR1, and this time is looking to guide all of you around some of the changes in connection with educational assistance. There have been a few. Frank, as all of you know, knows this language and the statute backward and forward, and is here to break it down further for all of us. Frank, thank you for taking the time from Albany. Please go right ahead.
Well, thank you for that kind introduction, Gabe. So as we all recall, on July 4th, the One Big Beautiful Bill Act was signed into law. Now, one of the many provisions of the act that actually positively impact employers addresses Section 127 educational assistance plans. Now, 127 plans have historically been provided employers and employees with a tax benefit for certain forms of educational assistance, and it serves as a valuable hiring and retention tool for many employers in the workplace today. Prior to the act, Section 127 provided an annual exclusion of $52.50 for employer-provided educational assistance pursuant to what's called a qualified assistance program. To qualify under Section 127 as an educational assistance program, it must, among other things, provide benefits exclusively to employees of the employer, which includes past employees. So this is not a friends and family type benefit. It must be current or former employees of the employer. It must be pursuant to a separate written plan that the employer has established, and it doesn't allow employees a choice between taking cash or educational assistance, nothing like that. And of course, the program can't discriminate in favor of highly compensated employees. The educational assistance provided under a 127 plan doesn't need to be part of a degree program. It can really encompass virtually any type of instruction that provides improved skills or development for an employee. And it would cover courses, of course, that are undergraduate and graduate level courses. But again, seeking a degree is not necessarily required. Now, the type of expenses that are covered under an educational assistance plan include such things as tuition fees, books, and similar payments, the cost of supplies and certain equipment, provided that the employee isn't able to return the supplies, must return the supplies and equipment following the completion of the course. And the cost of things like meals, transportation, and lodging can't qualify as excludable under 127 plans, even if these things were incurred in connection with attending a course of instruction. Now, additionally, Section 127 was originally expanded or recently expanded under the CARES Act. You may recall the CARES Act from the COVID era around 2020, and it was expanded through January 1st, 2026 to allow the exclusion from an employee's income of an employer's payment of principal and interest on what's called a qualified educational loan that the employee incurred even before they went to work for the existing employer who's going to be making this payment. Qualified educational loans include loans for tuition fees, room and board incurred by a student of at least half time at an accredited post-secondary educational institution. Also, loans that refinance a qualified educational loan themselves were considered qualified educational loans. Now, these loan payments on behalf of or to the employee must be aggregated with other benefits in determining the annual cap of $52.50. So the Act makes two really nice and important changes to Section 127 plan. Basically, the CARES Act, as I said, the CARES Act expansion to include the payment of student loans, principal and interest on prior loans, qualified educational loans, which was set to expire January 1st, 2026, is made permanent. So that remains in the statute. Additionally, the annual tax free benefit of 5250 has been capped for decades. So I looked this up, and it actually don't believe that 5250 limit has changed since 1985, and we all know that the cost of tuition hasn't gone up since 1985, right? But starting in 2026, the 5250 cap will be indexed for inflation, but for the close of this year, will remain at the 5250 level that we're all so familiar with. So given these two important and positive changes, employers should do several things. If you have a 127 plan in place, review the plan, make sure it encompasses the change originally enacted under the CARES Act about paying qualified loan payments on behalf of employees for tuition and fees and room and board for educational assistance to students. And also the plan should be modified to address the inclusion of the 5250 cap. If an employer doesn't have a 127 plan in place, this might be the time to initiate such a plan as a recruiting and retention tool. In any event, if you do have a 127 plan in place, it might be a good time to remind employees of the benefits available under the plan on their behalf. So that's really all I have on this today, Gabe. If there are any questions, I'm happy to answer them.
Frank, thank you so much, as always, for providing helpful updates that unpack what is pretty complicated material for the audience. And as Frank noted, if anyone has questions, he's more than happy to answer them. You've got Frank's email up there, and I know Frank would be happy to hear from you. Frank, I'm now going to turn to our last speaker, and that's Kamisha. Kamisha, welcome onto the program again, and thank you so much. Kamisha is an associate in our New York City office. And as part of Kamisha's role on this webinar to cover all things dealing with New York City one way or the other, it seems often that is what your task is here. I asked Kamisha if she'd look into the Manhattan DA, Alan Bragg, who had recently made some news locally concerning a wage fixing set of priorities that are distinct and perhaps replicated, because things that happen in the Manhattan DA's office often spread around the state. So we thought it would be worth your time just to hear a little bit about it. Kamisha, please go right ahead and let us know what you've learned.
Sure. Thanks so much, Gabe. So as you all heard Gabe mention, the Manhattan DA's office under District Attorney Alvin Bragg is using New York's criminal antitrust laws, namely the Donnelly Act, to combat wage fixing, which is a collusive practice that suppresses worker pay. This initiative, which was launched just recently in September 2025 by his Worker Protection Unit, is the first time local law enforcement uses antitrust statutes to address competitive wage suppression across various industries. Under the Donnelly Act, the DA's Worker Protection Unit can investigate and prosecute wage-related and other employment crimes. Now, many of you are probably wondering what wage fixing is. Wage fixing agreements are promises between individuals at two or more companies to limit employee salaries or, the terms of compensation to a specific level. Unless the agreement is considered a reasonably necessary part of a legitimate collaboration between the employers, such as a joint venture, such an agreement is deemed to be illegal under the antitrust laws and can also be subject to criminal enforcement by the Department of Justice. Wage fixing is deemed illegal because it harms the competitive market for labor. It harms workers by preventing businesses from competing for talent by offering higher salaries. And then it also restricts an employee's ability to seek better pay or other benefits by moving to a different company. So the Manhattan DA's office will be going after wage fixing agreements because it has found such agreements to be a widespread problem across industries in New York, especially healthcare and especially retail. So employers throughout the state, but especially those in those industries, healthcare and retail, should very carefully review their existing policies and practices to ensure that there are no efforts at all to minimize employees' competitive wages. And this will be so that they can avoid any liability under state or federal antitrust laws. Thank
And
you.
Kamisha, thank you for providing that brief summary. We'll be tracking all of this, and if we see activity out of District Attorney Alvin Bragg's office, I'm sure we'll be sharing it with the group. But in the meanwhile, this is really useful just to lay the groundwork for what may be coming. And so that brings us to the end of our formal programming for today. As always, you can contact me if you have questions. You can also contact any of the presenters. As we move into October, on the next program, you will have Carrie as your host. And then as we move into the middle of the month, I'll be back. Of course, we'll be tracking these and other issues that we presented on today as a group, because we know they matter much to the businesses and organizations that you lead. We thank all of you, as always, for your continuing effort to join us on Tuesdays, and feel free, as always, to reach out with recommendations for content. And in the meanwhile, we're wishing you a terrific afternoon and a productive end to September.